Hello and welcome, and thank you for joining me for the latest episode of the podcast. Today, I am delighted to welcome Kurt Lee back to the podcast. Kurt was my first ever podcast guest back in 2018, and this is, in fact, his third appearance. Today, we are exploring inheritance tax planning, deeds of variation, powers of attorney, the probate registry, and the Office of the Public Guardian. Kurt is a partner at Lester Aldridge Solicitors, based in their Bournemouth office, and he heads up the tax, trust, wills and probate team. So I am really grateful that he's made the time today to share his vast knowledge to help you live a better retirement and, of course, to be more informed. So please enjoy another interesting and valuable conversation with Kurt Lee. Welcome to the Retirement Café podcast. Welcome back, in fact, to the Retirement Café podcast, Kurt Lee.
Yeah, well, thank you very much, Justin. Thank you for having me back. It's always great to chat to you, and always enjoy listening to your podcast as well. So thank you.
Great. Well, for those who don't know you, Kurt, obviously you're a partner at Lester Aldridge and specialise in kind of probate and wills and trusts and all types of things around kind of estate planning and legacy planning and obviously our final demise. This is a big topic, of course, for retirees. So what since we last spoke, what are the big things that are coming across your desk that you're seeing that people need to know about?
Well, it's there's quite a bit going on at the moment, really. Delays with a lot of government departments, which I'm sure we'll come on to in just a moment, but also this sort of idea of increasing inheritance tax receipts for the government, and this idea of fiscal drag and more people being poured into the IHT net, as it were. It is a fact that most estates will not pay inheritance tax, but more and more people do. And I was reading something the other week, and it was about the sort of the boomer generation that have seen such a massive explosion in wealth and creation in wealth. And over the next 15 to 20 years, a lot of that wealth is going to be falling down the generations. And I can see that government receipts from inheritance tax are only going to go one way, and that's up. So it focuses a lot of people's minds.
Yeah. So these is this kind of one of the key concerns when people come to see you is about reducing their inheritance tax liabilities?
It is, and in fact, some people don't really need to worry too much about it. Other people do, but as you will know, as a financial advisor, that there's a lot of advice and a lot of circumstances that need to be taken into consideration. A lot of thinking goes into it, and of course, it's our job as advisors to sort of give our clients the tools and the information and ask the right questions that they need to be able to come to the right answers. It's not just a case of, can I give everything away? Well, you can do, but you might need some money to live the rest of your life comfortably. And they really need to be aware of that. So, it's our job is to focus their minds on that.
Yeah. And of course we see an awful lot of misadvice as well, don't we? That giving away your property and then continuing to live in it, doesn't generally work. Obviously there are circumstances where it can, but mostly that it can't. And then also the cost of care. People are frightened of cost of care, aren't they? And thinking that their property or their assets are all going to be eaten up in the payment of care. That's another thing that I get asked about quite a lot. I'm sure you're the same.
I do. I'm asked that question all the time, and actually it's one of the sort of big misconceptions about estate planning for a lot of people. Is this, they'll quite often say to me, can I just give my property to my children now? And I, as an advisor, I very, very rarely ever advise anyone doing that, unless it's a very sort of specific set of circumstances. And the reason for that is that, for a start, inheritance tax reasons, it just doesn't work generally. And you're also, for me, the clients who are thinking about doing that, they're giving away their main home, their castle, and they're giving it to their children, and there are all sorts of issues and risks involved in that. And, okay, it might ultimately work from a care home fee point, but, a local authority will only pay for a certain level of care, and if you want to be somewhere that's quite a nice care home, if ever you have to go into a care home, then someone has to pay from it from somewhere. And I often think that, sort of children have a potential conflict of interest in this, because on the one hand, they probably want to sort of try and preserve as much of the estate as possible. And that may conflict with the thoughts and the wishes of how the parent, the donor, what sort of retirement home or care home or nursing home they want to be in. So there's a lot to consider there.
Yeah. So you talk about the increase in inheritance tax, and obviously, I suppose in essence the inheritance tax hasn't increased, but of course our property values have increased and our asset values have increased over the years, and of course, people are inheriting often later. I know many clients in their 60s are only losing the last of their parent now. So, of course, that cascading of wealth comes down to the next generation, and then causes a further tax liability there. And I know we've considered D's of variation, and I've done a YouTube on D's of variation recently. But is that a tool that you often use?
It's a really fantastic tool, I have to say. And yes, quite often what I've been seeing over the last few years is, that sort of what I would call the sort of war generation, who are dying off, and their own children, as you say, Justin, that they can be in their sort of 50s, 60s, and their parents are still alive, they're still inheriting their assets, when they themselves, they already have an inheritance tax problem of their own. And one of the things that, very sensible thing to do is the deed of variation, to actually try and, for those people in their 60s, say, inherit from their elderly parents when they pass away, rather than taking it into their own estate, skip a generation, maybe pass it straight down to the children. But a slight variation and twist on that planning would be to actually sort of, for the sort of 60-year-old child, to actually divert that into, say, a discretionary trust, and then they lend themselves the money from that discretionary trust, and then they can give it away to their own children. And yes, that will start a 7-year clock ticking, but the advantage is, if they then survive 7 years from that period, the gift that you made to your children falls out of account, but your estate still owes a deductible IHT debt to the trust that you created when your own parents died.
Yeah.
So it's a really simple but really effective mechanism that can save a lot of money.
Yeah, so that's a great tax strategy already that only in the first 5 minutes, Kurt, that you've come out with. So discretionary trust, deed of variation, speak to Kurt if that is of something of interest to you. Now, we talked a bit about people who've got involved in, I know Which have come out with a report recently that people have got involved in a lot of trust schemes that have been sold for protection of care and reduction of inheritance tax, and are often not from authorised, kind of regulated advisors like yourself, solicitors, members of STEP, members of the Law Society, etc., the unregulated world of the will planning. And do you get to see some of this stuff and try and unwind it if it's gone wrong?
I do. I've had a number of occasions in the past where people have visited clients and they have tried to sell them. And I think that's the right word to use in these circumstances. What they're selling them is a package. And the good ones will actually then give me a call and say, well, I've met this person and they're proposing to do this. And my advice is, okay, stop, take a breath, take a moment, and let's really think about this, because there's so much to consider. Do I like those sorts of packages and schemes? No, I don't, for many reasons. One of the reasons is that they can sort of sell these packages and they charge a lot of money for them. Now, there's a lot of people have a preconception here that lawyers are expensive. Well, actually, these packaged schemes, these trust packages that people offer, they are really expensive. If you think lawyers are expensive, for me to create a trust, to transfer assets into it, the amounts that I've seen charged on some of these products that are sold, my fees would be less than that.
Yeah.
And in my opinion, you get better quality advice from a specialist in the field.
And of course, I always think about the recourse. If the advice has gone wrong, they can actually come knocking on the door of your law firm, can't they, and go, "Hold on, we've got some incorrect advice." If that was the case, a will writer can come and go and disappear, and we know that a lot of trust schemes have. Well, the trustees have disappeared, and that seems to have, what I've read about, it seems to have caused almighty distress for the people who are involved in these schemes, because they can't get hold of the trustees, and they find that their property is in essence owned by them.
That's right. Either that organisation ran itself through the form of a limited company, and perhaps that limited company has gone bust. But perhaps they're still named on the trust deed as trustees, and where do you go from there? It can be a real mess. Or you end up with individuals within those organisations who are named personally, and maybe they've gone bankrupt, or maybe their business is no longer in operation, or maybe they've retired, and it really can just be a real mess to sort out at what is then, for most families, a really difficult time, because someone's passed away and you're dealing with all of that emotion. You're trying to organise one's affairs, and yet you've got all of these complications, trying to track people down, find out where they are, see if the company entity still exists, perhaps realise that the wrong advice or bad advice was given, and then, as you say, what recourse do you have there? And yes, of course, some law firms do cease to operate as well. But even in that scenario, the Solicitors Regulation Authority has a compensation scheme as a backup. If all else goes wrong with a law firm, there is still the ability to make a claim against that fund. So there is a great deal more protection when you do go through a solicitor. And, I challenge people's perhaps preconception that lawyers are expensive. In the scheme of things, I don't necessarily think that we are. No. And I think the quality advice and the recourse if it goes wrong is also one of the aspects that you pay for.
Yeah. And of course, it's a bit like, I always give the analogy of, when you insure your home, you hope that it's a waste of money. You hope that premium is just kind of thrown down the drain every year. You don't want a return from your home insurance premium. It's there because it's there for protection, but actually you hope that you're actually going into the street and you're tearing up £10 notes. Because if you can pay those premiums for 30 years and never get any compensation back from it, brilliant, because it probably meant that you haven't suffered a disaster. And again, I suppose that's the same type of thing, isn't it? You get good legal advice from a good firm, do all your due diligence, check them out, make sure they're a member of STEP and the Law Society and all that type of thing. But then also then go, well, you know, to a certain extent, I hope it's a waste of money on the basis that actually I'm never going to have a problem because it's all going to go well when I do finally die, and it's just going to, you know, just run through the normal process. Now, talking about normal process, we then move to the point, don't we, where you mentioned earlier about government departments. And, of course, the normal process once someone dies is that we have to enter into something called probate. For those listeners who aren't aware of how probate works, if you could do a kind of a quick, you know, summary of that, and then also explain where you're finding difficulties.
Okay, so I think the real problem when someone dies is that the assets that they owned are technically frozen. Now, if the person owned assets jointly with someone, that could be a joint bank account, property held as joint tenants, then that may be fine. That asset can pass immediately to the surviving co-owner of that asset without any need for a grant of probate or anything like that. But one of the things that I find quite often, and particularly with a certain older generation, is that one spouse, with that generation, usually the man, had a lot of bank accounts and savings accounts perhaps in his name. And then he passes away, his accounts are frozen, and the widow doesn't have any immediate access to them if it's above a certain threshold and the banks aren't willing to sort of release those funds early. Everything's tied up and frozen. So I've seen cases where it can cause real hardship for the widow or widower who's left without access to sort of capital sums or even a spouse's pension just while things are getting sorted out in the meantime. So probate, very simply, on death, assets in the name of the deceased are technically frozen, and then you have to sort of go through this process of obtaining a grant of probate from the court. You then need to work out whether the estate is a taxable estate or whether it's not, and it's then sort of pulling together all of that sort of asset and liability information for the one who's died, in order to determine whether it's taxable or not, or whether you can just go straight for the probate application. You then go through that process, which is taking time, which we'll come on to. But once you've got the grant of probate, that then gives the executor the power to release or unfreeze those assets, collect them in, have them transferred, and then distribute them in accordance with the terms of the will. Now, at the moment, we are seeing really, really significant delays with a lot of the government departments. In my sort of professional life, the main departments that I deal with are HMRC, the Probate Registry, the Land Registry, Office of the Public Guardian, and the Court of Protection. And with all of those government departments, there are really, really significant delays. If you send documents to HMRC, if you get a reply within 6 to 12 months, you're doing really well. The Probate Registry, it's a bit hit and miss there. If it's a taxable estate, you need to, potentially prepare and file an IHT 400 form, send that to the revenue first. Assembling and completing that form can take some time in itself. And then you have to wait sort of 21 working days or so before you can then apply for the grant of probate. If it's not a taxable estate, you can go straight to the probate application. And here, the probate registries, they are taking quite some time. Although having said that, on some very simple applications, where it's not taxable, one of my colleagues, I think, had one back in a few days. Right. Which is just remarkable. But that is very much the exception at the moment. The rule is months, and of course that then creates problems in itself. As I said, if assets are frozen and you don't have access to them, and you're waiting months for a grant of probate, that can cause real problems for the spouse, the civil partner, the children, and the executors. And one of the big problems with how long it's taken at the moment is that for inheritance tax purposes, there are some very strict time limits that apply to an estate, particularly when investment, stocks and shares are sold at a loss from its probate value. So someone dies, all of the assets are valued as at that date. Say the market takes a downturn and the executors then sell those stocks and shares at a loss. They have only 1 year after death in order to go back to the revenue and say, we've sold these shares at a loss, can we have some tax back? But of course, everything is taking so long at the moment that there's a real danger of actually missing that time limit, that deadline to deal with matters. It's a bit longer for property, you've got 3 years there. But these are sort of some of the practical problems that we're having to deal with at the moment.
Yeah. And Kurt, just taking a step back, you mentioned all the departments, the government departments that you will deal with in your professional world. And I'm sure as you become, I know you've been doing it, for a few years now, and therefore had quite a big experience. But you mentioned a number of departments. So HMRC, I'm sure most people will be familiar with. This is where they pay their tax to. But there was a couple of other departments. So you've got the Court of Protection. I think you mentioned the Probate Office, the OPG. Could you give a kind of a quick synopsis of what those organisations do and who they are, just for people who are not familiar with them?
Yeah. So let me start with the Land Registry first of all. Of course, they deal with all UK-wide property, and very significant delays there at the moment because they are, number one, understaffed. Number two, they are prioritising for value applications over non-value applications. So normal sales and purchases, they're going through not too badly. But when you've got an estate, say, and an ascent of the property, a transfer of the property out of the deceased name into the beneficiaries' names, that's taken a really, really long time to deal with at the moment.
Now, just on the one of the key things I think you mentioned earlier, which is obviously joint assets upon death will fall directly to the last named person on the asset, in essence. So a couple, if they've both owned the property jointly, then it'll be just in the one name. So obviously we've got to inform the Land Registry of that change.
Yes.
But to a certain extent, it doesn't really matter how long that generally takes because there's no tax to pay on it, and we just need it to happen. In my experience, an awful lot of the time, people don't actually know how they hold their property.
No, that's very true. And there are two ways to own UK land and property. One is as joint tenants, the other is tenants in common. With joint tenancy, the feature of that is that regardless of the contents of your will, that property will automatically and immediately vest in the surviving co-owners. Whereas with tenants in common, there is a difference here between the underlying beneficial interest and the legal title. So legal title still vests in the surviving co-owner, but beneficially, the interest of the one who dies can pass in accordance with the terms of their will. And it can be really important to know how you own that property. And you can check with the Land Registry as to how you own it. Most married couples tend to own it as joint tenants because generally that's what most people want. If anything happens to one spouse, it automatically passes to the other. But if, say, you are on a second marriage and there are children from each of the husband and wife who are separate, then you may not want that your interest in that sort of jointly purchased property to pass by way of survivorship to your second spouse. You may want to ensure that actually your interest in that property, it is there for your spouse's benefit, but ultimately you may want that to pass down to your children. And if you want that to happen, you must own it as tenants in common and have a will in place to deal with that. So it's a really important point, actually.
Absolutely. So if you're in doubt, you contact the land registry and establish how you own the property.
That's right. And the way to tell, because it's not very obvious, but if you own it as tenants in common, there will be what's called a Form A restriction on the title, and it will say something along the lines of no disposition by a sole proprietor except by permission of the court. And what that means is that a single person, a single legal owner, cannot actually sell that title and give overreaching, good title to it unless they appoint a second co-trustee of land to do that. It means that, really two people have to sell that property. And, that's what it works. That's what you need to look for.
Yeah. Yeah. And so, of course, in transferring, if your husband or wife has died and you need to contact the land registry to get that property into your own name, how does someone go about doing that?
There is a specific form called a DJP, Deceased Joint Proprietor Form. You can complete that form and you can submit that to the land registry with a death certificate, and then they will be able to remove the deceased's name from the title register, which will leave it just with the surviving co-owners.
Brilliant. Okay, who's next then? Who's next on the government department hit list?
Office of the Public Guardian.
The OPG.
Lasting powers of attorney.
Right.
Again, this can cause real problems potentially. The length of time taken by the OPG to register an LPA is frankly ridiculous at the moment. It's taken 3-4 months to deal with that, and you can imagine, and this is one of the reasons why I always recommend that LPAs are registered as soon as they're completed and signed up, even if they're not going to be used straight away. You can imagine a scenario, say someone does have a lasting power of attorney, but it's not yet registered. Something happens to them, they have a stroke, they're involved in an accident. Next of kin comes along, they pull out the lasting powers of attorney, but they're not registered. They can't be used unless they are registered. So they send them off to the Office of the Public Guardian, and they're waiting for 4 months perhaps in order to get them back. And what happens in that sort of lacuna, in that period of time, if someone is unable to deal with their affairs, I mean, it can cause huge problems. And my understanding with the Office of the Public Guardian, all the post goes to an office in Birmingham. They pull it apart, they feed it through a scanner. Hopefully all the pages are scanned and not lost, which I've had in the past. And then, it will be processed. There's a waiting period for registration that you have to go through. But, it's just taken an age, and really, they really do need to get their act together. It's just not good enough.
No, and it's something that I make sure for every client that we continually badger them to have their LPAs completed and registered, because I just explained to them, I said, look, if one of you comes in, and you've been coming in as a couple all these years, and one of you comes in and says, my husband's diagnosed with some dementia or what have you, and he's we've got the power of attorney, we've got the power of attorney, we can help, we can advise on those assets, but if we haven't got it, it's not been registered, we can't. And that, I know that sounds crackers, but we've been, dealing with you for the last 20 odd years, but the reality is I can't now talk to you about those assets unless we've got that power of attorney registered. And we're acting, we only look after currently about 80 clients, 80 families, and we've got 3 currently under with powers of attorney enacted, that
Yes.
we're working with the attorney.
Yes, I think for a lot of people, they are concerned that, you know, if the LPAs are registered immediately, will the attorneys have access? You know, they'll be able to see their and access their bank accounts and that sort of thing. Well, technically yes, but you know, one of the things that I said to clients is, look, when the LPAs are registered, they'll come back to me. We'll keep them in our archive store here because no one needs to use them right now. If in the future something happens and they do need to be used and activated, then, you know, your children will get in touch with me. They'll say, you know, something happened. We need to start operating the lasting power of attorney. And I can perform a sort of a check and a balance to go back and say, well, you know, what's happened to your mum? You know, what's happening there? Is there, you know, do we need to get a mental capacity report? And just check that, okay, actually, yeah, you do need these powers. Here's a few certified copies. This is what you need to do with them. And I think that's an additional safeguard that we as professional advisors can provide to them.
Yeah, brilliant. So we've done Land and Registry, OPG. I mentioned about HMRC. You might tell me some disaster stories there as well. But who else you got on?
So the Court of Protection, which is within the same sort of government realm as the Office of the Public Guardian, but the Court of Protection applications. This is where perhaps somebody has had to apply to the court for a deputyship order because they don't have a lasting power of attorney or an enduring power of attorney. And again, I mean, court applications were always quite slow. But now, unless it's a very urgent application, the Court of Protection is also very slow. Court hearings, the processing of forms, it really has just ground to a crawl, really.
So when you say slow, if we wanted to go to the Court of Protection for somebody now, today, how long would you expect that to be approved? For a deputy to be appointed?
Yeah, I mean, I would sort of... if you get the order within about sort of 9 months, I think you're doing quite well. But of course, that is a very long time in someone's life who may be in a very desperate situation.
Yeah. Awful. Anyone else we've missed?
Well, it's really just HMRC, yes. Isn't it? HMRC. I've been working in the tax profession now for coming up for 26 years. And when I started in tax, HMRC were actually really quite good. There were lots of local tax officers. There were lots of inspectors who knew their stuff. I mean, they were really good. And you could pick up the phone, you could have a conversation with the local inspector, you'd have a bit of a negotiation and you would settle. And then, of course, all of the local tax offices have been closed, it's all been centralised. I think a lot of the really experienced technical inspectors have sort of retired, haven't been replaced in the same numbers. So what we end up with now is a service which is frankly creaking at the seams. And you can send your forms or a letter to the revenue. It will sit in the post queue for at least 3 months. You may not get a reply for 6, 9, even 12 months later. You're chasing for a reply because you want to sort of deal with matters. Maybe you're looking to finally wind up an estate that you've been dealing with and you just can't get any sort of response from the revenue on that. And then the funny thing is, when you do eventually receive a letter from HMRC and they're asking you for information, well, they want it within a 4-week turnaround. Well, okay. I mean, so when I reply to them, and I will quite often say in my letters now, well, I want to reply in a 4-week turnaround as well. Thank you very much. It doesn't often happen. The thing about that, you know, all the civil service departments is that you know, they call people customers, but they're not customers. You know, they they offer a government service, and you can complain all you want about them, but they will just work at their own speed. Whereas, you know, with a business, you know, if it's your business, as you know, Justin, you need to keep your clients informed about what's going on. You need to keep them up to date. You need to provide a really good service. Otherwise, you're going to lose them.
Yeah.
Different mentality.
So I'm hearing some really key messages here. Is that if someone's sitting there thinking, right, okay, I need to get my affairs in order, they've obviously got to do this kind of classic thing of make a will, consider the inheritance tax, get the powers of attorney completed. But one thing I know that I'm approached with regularly, and I'm always conscious of the people who aren't clients who are listening to this podcast and how we can help them, is try and simplify your affairs. Try and simplify the scenario. So if you have a property, make sure it's in joint names. Make sure there is a joint bank account, so that your surviving spouse or surviving partner can access some funds if necessary, or they've got their own independent funds to be able to maintain their quality of life for, it sounds like, at least 12 months before they'd need to call on the resources of their partner or spouse, or deceased spouse. And you know, maybe the less accounts that you've got, the better. I appreciate that we're all kind of trying to find good rates on our savings accounts, and we'll all have lots of different products, but actually trying to simplify that as much as possible, and to have your affairs so that actually if someone it does get to that application for a grant of probate, or it's an estate that is going to have tax to pay on it, it's relatively, you know, the information is there and relatively easy to put down on the form, so that whoever is the executor can make the application relatively quickly.
Yes, I mean, absolutely right, and very sound advice there. Many years ago, you know, we had, you know, we would sort of often advise clients to have what was called a dying tidily log. And this is just a very simple list of your main assets and liabilities, which from time to time you would update and perhaps keep a copy with your will. And it's just making a note of the bank accounts and the savings accounts that you've got, you know, bank loans, credit cards, anything like that at all. Where, you know, what investments you have, who deals with them, and just a sort of go-to list. And that's really important for a number of reasons. Number one, it saves a huge amount of time, and if you instruct a solicitor to deal with the administration of an estate, time costs money. So if you've got those records all ready to go and you can hand it across to a solicitor in one package of documents, that makes our job a lot faster, a lot easier, and therefore much cheaper as well. So, you know, that's really good. I think the challenge that we face for the future is that more and more information is being kept digitally online, and I don't think anyone has yet got a really good solution to how we might deal with that. I know there are some apps now that are starting to come through where people can keep their records on these apps, and they can delegate or provide access to professional advisors and so on in certain circumstances. But there are a few providers at the moment, and I think one of the issues generally with that is that, you know, people of a certain generation are perhaps a bit wary about keeping all of that information digitally online. Maybe they're worried about security. But also I think until a dominant player comes into that or establishes himself in that sort of digital market, I think a lot of people have concerns. Well, if I use this provider and then that goes bust, is that going to cause a problem? And again, those apps can come with a monthly subscription of sort of £5 or £10 or something like that. And do people really want to do that? It's a really difficult thing. The problem we have tracking down digital assets is that there's not necessarily any paper trail to do that. And I don't think there's any real answer to that problem at the moment. I don't know if you've come across anything that sort of really works in that regard.
Yeah, I did actually. The other day I came across a Dutch company who's running, I can't remember what they're called now, who's running one of these online apps. But again, you're absolutely right that it's the essence is, well, are these people still going to be around in 15, 20 years' time when I die? Now, I appreciate that you can move from one thing to another. I would think it's a massive opportunity for the banks maybe to offer us something. I mean, I know as a financial planning company, we have a secure document repository where people upload their wills, their powers of attorney, their tax returns. We have their investment statements. We put their income expenditure. We do the inheritance tax form regularly, just so that we've got all the information in case someone dies, so we know what their IHT liability is. So we're all doing that, but of course that's a very small scale. 80 families we're looking after. So maybe individual firms like yourselves can offer that type of service. If you're offering an estate planning and will writing service, maybe that is another opportunity for you to add an added service that that is available. But again, law firms can come and go as well, can't they? So you would have thought someone like a bank or an insurance company could step into that space where you think, well, actually, there's a good chance that Aviva is still going to be in existence in 25 years' time.
Yes, absolutely. But failing that, pen and paper, written hard copy note with your will, I think can work just as well.
Yeah, just being on top of the game, and it's not something you have to do regularly. And of course, access. We don't want everyone to be writing down all their passwords, but how on earth do we access all those digital records as well when they're not here?
Yes. But it's one final point on that. I think it's really important that your sort of next of kin or whoever they are, they do know where, in the event of your demise, that they know where to look or they know who to go to. Because quite often in wills there may be wishes regarding funerals, there may be organ donation wishes. So I think two things: really important that your next of kin know what your wishes are, and they know how to sort of, if they don't know what your wishes are, that they can very quickly access a copy of your will to find out if you've left any wishes in that regard. Obviously, with things like organ donation, time is of the essence. So, it's really important that you have that conversation with your next of kin and you let them know what your wishes are in that respect. Yeah,
brilliant. Well, Kurt, once again, thank you for joining me on the Retirement Café podcast. It's been fascinating again hearing all your insight and knowledge about what's going on in the world of legacy planning and and all the complications that are coming with these government departments. I would absolutely be very happy to hand over that responsibility to you in the event of something going on in my family. Well, yeah, thanks so much, and once again for all your knowledge and insight.
No, thank you very much, Justin, for having me back onto your podcast. It's been great, always great talking to you.
Thanks, Kurt. Thanks once again to Kurt Lee for joining me today. I am sure he has given you some insights into how you should approach your tax planning in your retirement. Check out the show notes for some useful links on what we've discussed today. And of course, as ever, if you've enjoyed this episode, please do leave us a review on Apple Podcasts. It really does help more people like you find us. And for more interviews and retirement planning videos, you might want to check out my YouTube channel. You can just search for Justin_King or click the link in the show notes. If you want to get in touch with feedback or guest ideas, you can reach me on hello@theretirementcafe.co.uk. So until next time, I'm Justin King, helping you feel more informed in your retirement.